Welcome to Ekam Academy. Today we are going to discuss about Supreme Court's statement with respect to SBI on electoral bonds. So why Supreme Court became very serious on SBI for not disclosing the information related to electoral bonds? What is the journey that happened so far with respect to electoral bonds? We'll know the features of electoral bonds, and also Supreme Court said clearly that in case if SBI couldn't disclose the information related to electoral bonds by tomorrow, even will initiate contempt proceedings against SBI. So we'll know what are the main five key highlights of today's Supreme Court judgment with respect to this disclosure of information pertaining to electoral bonds in the context of this particular event. So you can see on the screen, Supreme Court has rejected SBI's plea. So they said, what steps did you take in the last 26 days? That means on February 14th, if you have seen, there is a judgment passed by the Supreme Court unanimously stating that this electoral bond scheme is a violation of constitution, because they have quashed the scheme mainly saying that it is a violation of Article 19, right to know. So when the person is elected, so the person whom have voted for him has a right to know from where that party is getting funding, who contributed to that party's funding and all. So in this context, the Supreme Court has opined, in case if there is donor anonymity that is maintained with respect to electoral bonds, it is a clear subversion of this right to know. In that context and many other things, after detailing all these things, Supreme Court has made the scheme unconstitutional. We'll know what happened in the timeline briefly. So, in 2017 itself, electoral bonds were introduced. Electoral bonds were introduced by the government of India through Finance Act. Okay. Subsequently, many other acts were also amended. We'll see in the later part of the video. Subsequently, this scheme was introduced. After this, what happened between 2019 to 2024? So many political donations and political funding happened. But subsequently, as the provisions of this electoral bond scheme mainly have given a provision of donors anonymity. So the one particular organization called Association for Democratic Reforms, they have approached the Supreme Court challenging this. Okay, so because this is a clear violation of right to transparency and accountability in terms of political funding. So after examining and after a series of petitions filing and after reviewing all these things, Supreme Court in 2024 February, it has clearly said this electoral bond scheme, if it is maintaining this donor anonymity, is clearly unconstitutional. So it was quashed, okay, or it is crashed by the Supreme Court already. But now what happened on the particular judgment on the same day only, Supreme Court has stated the largest public sector bank of India, that is SBI, to disclose the information related to electoral bonds by March 6th. Okay, so they have given some ample amount of time, and they said SBI has to give this information relating to who have bought this bonds, how much did the party entitle from the after encashing the bonds, how much they got. All these things need to be disclosed by SBI to the Election Commission of India by March 6th. This is what Supreme Court has given clearly as part of its verdict. Then what happened subsequently? Supreme SBI on March 4th of this month, okay, March 4th, it approached the Supreme Court stating that it wants some extra time. So as there is so much of information with respect to electoral bonds and all, almost 22,000 bonds were purchased between this 2019 to 2024. So as there is a lot of data that has to be determined and that has to be examined, they said we cannot disclose just by March 6th only, and we want till June 30th. The date of our deadline should be extended till June 30th. This is what the SBI has requested. Why SBI is involved into this issue? Because these political parties, okay, so the political funding can be given through the political parties through electoral bonds. Who can buy this electoral bonds? Again, any individual person or company or even a foreign company will know what are the things that are essential criteria for contributing to the electoral bonds. But these persons, okay, in case if they wanted to contribute to the political party, they have to buy these electoral bonds only at the designated branches of SBI. SBI is the only authorized agent, okay, you can say in terms of electoral bonds. In the authorized branches only, on specific dates only, SBI is authorized to issue these electoral bonds in certain denominations. So there is no maximum limit set on the particular amount that a person or a company can contribute to the political party, but these things have to be only done by through the channels of SBI only. So as the SBI is involved in buying these bonds or in help facilitating the persons to buy the bonds and to encash these bonds by the political parties, SBI is asked to disclose this information. But what SBI said, we cannot disclose immediately by March 6th, but we want some extra time to because of bulkness of the data, and we will submit by June 30. This is what the SBI has informed to the Supreme Court. But in the meantime, what happened again? This ADR, Association for Democratic Reforms, it has filed a fresh petition before the Supreme Court stating that in case if there is a delay in filing this information, clearly that can be misused for the upcoming Lok Sabha elections. Okay, that means some data hiding or something can happen. So that is why they have urged that this has to be disclosed immediately. So filing this petition, Supreme Court has taken up this petition today itself, and it has clearly mentioned that by tomorrow means March 12th only, the SBI is asked to disclose the information to the Election Commission of India. So by tomorrow itself, in case if SBI couldn't disclose this information, then what happens? Even we'll launch or we will initiate the contempt of court proceedings for willful disobedience of the orders issued by the Supreme Court. In this context, we'll know what are the contempt proceedings also. But another thing they said clearly is, even this Election Commission, after getting the data from SBI, they has to make this data public, okay, by March 15th. By March 15th means within 3 days they have to upload the data on their website regarding the political contributions through this electoral bonds. This is what clearly given. So we'll understand what are the 5 major highlights of today's judgment with respect to this disclosure of information. Then we know what is the concept of contempt of court, because today itself we have clearly have heard this term. Even SBI also, when it failed to disclose the information, then even contempt proceedings can be initiated. That is what Supreme Court has warned State Bank of India. So we'll know what is this contempt of court proceedings, how many types of contempts are there, whether this contempt is having any constitutional backup or there is any legal provisions that has given such powers to the Supreme Court. Then we'll know what are the arguments in favor and against, because previously also there are some points in favor and against the contempt of court. And then at the last, we'll quickly see what are the electoral bonds, what are the features of this scheme, and why it was scrapped by the Supreme Court recently. So this will be the points of discussion today. You can see on the slides. Electoral bonds, ADR versus SBI. ADR is one organization or association which has filed this against SBI for failing to disclose within the given time. So why in news, we'll see what are the electoral bonds, why they were introduced and how, when they were introduced, what are the issues associated, why they attracted criticism. This we'll see at the end. Today we'll mainly see what are the 5 key highlights of the Supreme Court verdict with respect to disclosure of information by SBI. With respect to this, and we'll know what are the contempt proceedings and what is the way forward. So here the point of discussion will fall under GS paper 2 as part of polity and governance. Then we'll understand why it is in news. Supreme Court has asked SBI to share the details of electoral bonds with the Election Commission by March 12th. Already I told you, okay. So when it was squashed in, when it was, the scheme itself was scrapped in February, at that point of time, SBI was asked to disclose information by March 6th. But again, subsequently by March 4th, so this SBI has filed a fresh petition asking that they cannot disclose, and we wanted to extend this deadline to June 30th. In light of this, again, ADR has filed a fresh petition asking that this data of delay of disclosure of this data, in case if there is a delay, that may threaten the coming elections also, and they subvert the election procedure. Okay, that is why they have approached, and Supreme Court today has clearly said SBI will not be given any deadline. So in this context, we'll understand what are the 5 key highlights of the verdict. Okay, first thing you need to know is SBI was directed to give details by tomorrow itself, that is March 12th. So after scrapping the electoral bond scheme, Supreme Court on February 15th, it has directed the SBI to submit all the details regarding to this electoral bonds to the Election Commission by March 6th that we have seen. So on March 4th, as I told you, SBI has approached the court seeking the extension of this till June 30th. That is what we have seen. Today, the five-judge constitutional bench, again five-judge constitutional bench, they have clearly rejected the SBI's time extension plea, and they have ordered that they have to disclose this to the Election Commission by tomorrow itself. This is the first major highlight we already have understood. Then details on the election website should be made public by March 15th. Once if the SBI furnishes this information to the Election Commission, then it has to be posted on the website. So the dates assume significance because now Election Commission of India is to schedule the Lok Sabha elections, upcoming elections. Anytime it can be out the schedule. So in the light of this, this particular data will assume significance. Then Supreme Court also has warned the SBI that it will initiate contempt proceedings in case if they don't follow this. What is the contempt means? In case of willful disobedience. That means after issuing of orders also of the Supreme Court, if you are not abiding or if you're not following the orders, then it is called as contempt. One of the contempt we have is civil contempt and criminal contempt. We'll see. So this is also issued. This is said as the Supreme Court that in case if they don't follow and if they don't disclose by March 12th, tomorrow, then contempt proceedings can be initiated against SBI. Then Supreme Court has rejected this 2C law argument. What is this argument? So as I told you earlier, SBI in a plea, it has said almost there is large number of data with respect to electoral bonds. Almost 22,000 plus bonds were purchased in the 5-year period. So to understand this, and to decipher to understand this and to decipher this particular data, okay, they require some time. So but Supreme Court has refused this particular argument of this 2C law argument, you can say. Then fifth one is no donor political party link. This is very important thing, as important aspect of today's judgment, you can say. SBI was requested to publish the details of the purchaser who purchased that bond and the denomination also. Denomination means in how much amount they have bought that, and also details of each electoral bond which is redeemed by the political party. These things have to be disclosed. Then what happened? However, now Supreme Court recently, based on the SBI's request, has given, or you can say acceptance was given not to link this donor with the political party. That means here, what will be disclosed by the SBI? Who purchased the electoral bonds? Their details will be revealed, and the denominations, how much they bought, will be revealed, and how much the political parties encashed. Means how much they have used as part of the electoral bonds. Okay, so you know already if there is no proper encashment, or if any particular bond is not encashed by the political party, then what happens? This money will be going to Prime Minister's Relief Fund. This is a main provision of electoral bonds you need to remember. In case and if any party doesn't encash, then that money will be gone to the Prime Minister's Relief Fund. So here the Supreme Court agreed that the donor and political party link means which person have contributed to which party. This particular data will not be revealed. That is what SBI has requested, and subsequently Supreme Court also has agreed upon this. Then we'll understand what is the contempt of court. As I told you, contempt of court is nothing but to protect the judicial institutions from attacks or unwarranted criticism. That means in the delivery of justice, okay, in case if they pass any judgment or so, if no one, or if someone doesn't like the judgment, if they think the judgment is not in a position to do justice or something, if they criticize the court, okay, then fair criticism is accepted. But in case if that fair criticism is not there, and if that criticism may dismantle or it like you can say lower the court authority or scandalizes the court's authority, then that can be considered as contempt of court. Okay, so this can be done by the Supreme Court on its own motion only, and it has its origins in the England. Okay, where you have common law. According to the common law, the king will have the power, okay, with respect to this issuing of contempt proceedings. Okay, from there we have taken this particular provision. Statutory basis, if you see, not only directly there in the constitution under article 129 of Indian constitution, where there is one provision. For example, if you have seen, article 129 says Supreme Court has power to punish for its contempt. Okay, in case if contempt of court will be observed, then Supreme Court has the powers to punish for contempt of court. That is there in the article 129. But explicitly it is also there in the restrictions on freedom of speech and expression. Freedom of speech and expression is part of 19 clause 1A, and under this 19 1A to 1F you have different fundamental rights, but 19 clause 2 you have where some reasonable restrictions even can be imposed on these particular freedoms. So on this, one of the ground of restriction is contempt of court, because fundamental rights are not absolute, so they can be restricted under some restrictions. Such restrictions under 1912 you have is this contempt of court. And separately, as I told you, 129 will specify that Supreme Court has power to punish the contempt. And similar powers are also there for the High Court. There are similar powers to the High Court. Now do remember, only Supreme Courts and High Courts have the power to issue for contempt proceedings. And coming to the subordinate courts, subordinate court doesn't have the power to issue contempt proceedings. Those are there with the High Court itself. That means, in case if any contempt proceeding has to be issued in terms of subordinate court, that can be done by the High Court only. So again, subsequently, Contempt of Court Act 1970 was one act enacted to give the statutory backing to this idea. Then we'll understand what is a suo motu action. That means without any permission, only from the Attorney General. Attorney General, highest law officer of the country, 76 Article 76, he's a public pleader, you can say. So he represents the government of India in many cases, right? So it is not required here, prior consent of the AG is not required to initiate the contempt proceedings. So Contempt of Court Act 1971 says this cannot be limited by the permission required. So only the procedure is mentioned under contempt of court. Okay, so they cannot specify a condition, because previously they tried to include a provision that Attorney General's prior consent is required to initiate contempt proceedings, but now subsequently that was removed. Okay, you need to remember this. Then two types of contempt we have. One is civil contempt and criminal contempt. Civil contempt means willful disobedience of the court's order or any particular order issued by the Supreme Court if it is not followed. The same thing against SBI also Supreme Court has warned it will initiate. Then criminal contempt means three types of things are there, like words written, spoken, which scandalizes or lowers the authority of the court. In case if any gestures of these things, okay, so if they scandalize or lower the authority of court, then criminal proceedings can be initiated, or any prejudices or interferes with the judicial proceedings, anything if it interferes, then also if any obstruction causes to the judicial proceedings, then also criminal contempt can be initiated. And if it interferes with the administration of justice or obstruction of justice, then also this criminal proceedings can be initiated in the relation of contempt of court. Then what is the objective? Why this contempt power should be there with the Supreme Court means, normally in Supreme Court, okay, so most of the people will believe always Supreme Court will give what is good for the society. In that context only it will pass its judgment. But in case of the judgment passed, and if you wantedly or if willfully if you wanted to make a criticism so that the public's opinion or public's point of view with respect to Supreme Court changes, or it will the dignity of the Supreme Court which the public will hold with them, if that is willfully like you can say neglected or willfully caused, willfully you can say, if you're wantedly or intentionally, if you're wanted to demoralize or wanted to decrease the authority of the court, then such proceedings can be initiated. So they don't want any malicious intent behind the contempt proceedings. Okay, in case of fair criticism, Supreme Court will accept, but in case of malicious intent behind this particular thing, then contempt of court proceedings can be initiated. Then what is the punishment that can be given? That means almost 2,000 rupees fine, or 6 months simple imprisonment can be initiated. 6 months simple imprisonment can be initiated in case of contempt proceedings. And if you have remembered, one of the Supreme Court advocate, Prashant Bhushan, okay, so even against him also in the recent times Supreme Court has initiated contempt proceedings, but only 1 rupee fine was awarded to him, okay, because they wanted, just because of his contributions to the judiciary previously, they didn't have increased this punishment or fine. Then what are the arguments in favor of retaining this contempt provisions is increasing the instances of contempt and scandalizing. So in the recent times we are seeing many number of situations where there are malicious intent or malicious criticism against the judgments of the Supreme Court, so that the public's feeling or dignity with respect to Supreme Court will vanish. That is why the reason is they have to have this provisions of contempt. Then maintain supremacy of law. So here Supreme Court is not an particular body, like particular authority which is always against the government. In maintaining the rule of law, or in maintaining justice only, it has to give some particular judgments. So to maintain the supremacy of law in the constitution, it is necessary for the Supreme Court, okay, sometimes to have these powers. Then constitutional source of contempt. Already we have under Article 129 and under Article 19 clause to one of the reasonable restrictions is contempt of court. So these things already have constitutional backup. And the impact on subordinate courts. So in case if these contempt proceedings are not there, then right from the subordinate judiciary itself, the people will willfully not follow the judgments passed or degrees or orders passed by the subordinate courts. Then there will have a lot of impact on the judiciary also. That is what the maintains the administration of judiciary. So to maintain this administration of judiciary and to uphold the judicial spirit also, it is very much important to have this contempt proceedings, and adequate safeguards also need to be ensured, okay, to maintain the independence of judiciary. In this context, we need to know, we need to have this contempt proceedings as part of our constitution and legal process. Then what are the again provisions against the contempt of court means? This is against civil liberties. Article 19 you have freedom of speech and expression. So under speech and expression, one of the restriction is contempt of court. So this is against this fundamental freedom of speech and expression, and Article 21 right to life and personal liberty. And there is wide scope of contempt. So lot of things are included under the contempt. This may narrow down the freedom of speech and expression and right to life, and no one can be a judge in his own case. If you know the principles of natural justice, we have one of the basic fundamental thing in under principles of natural justice, you have two things. One is no one can be a judge in his own case, okay, that is the fundamental one basic principle of natural justice. And you have second provision, that is odi alterum partem. Okay, odi alterum partem means no one can, without hearing the other side, you cannot pass the judgment. Okay, so these are the two essentials of principles of natural justice. So here no one can be a judge in his own case means here Supreme Court only is initiating the contempt proceedings in case if it is vandalized or scandalized. So that is the main thing which is against this provision of natural justice. Then in one particular case, that is S. Golkar versus Unknown in 1978 case, Supreme Court said you cannot use contempt proceedings very frequently or very regularly. So only when there is malicious intent behind the particular comments passed against the judiciary, then only you can initiate this contempt proceeding. So this judgment itself is saying it should be sparingly used. Then what are the electoral bonds? We already know. These are the financial instruments used to donate to the political parties. So these are interest bearing bonds, you can say. So they will be redeemable by the political parties through the bank account. So in what denominations? There is 1,000, 10,000, 1 lakh and 10 lakh, 1 crore, up to these denominations they will be available. There is no maximum limit. This is the most important thing. Then who can issue? SBI. That is why in the today's case also SBI is involved. Bond validity is 15 days after the date of issue. Within 15 days, political parties have to encash their bonds. So these are the redeemable, you have to remember. Then most important, who can purchase the bond? Okay, so citizen of India or company or incorporated in India or established in India. If you have seen previously, before this electoral bonds, only profit making companies only were allowed. If they earn only 7.4% only, they can, if they are earning profits only 7.5% of their profits only, they can contribute to the electoral bonds earlier. But with the electoral bond scheme, there is no limit they have set, and even loss making companies also can contribute. That is a recent amendment made with the electoral bond scheme. That means individual, company or even foreign entities also can contribute. Then purchasing bond, if you see, for 10 days each within the months of Jan, June, April, July and October as specified by central government, these bonds will be issued by SBI. So the donors can buy from the SBI. Then these can be encashed by the political party subsequently. So in this way the political funding works. So the donor's name is not mentioned. That is the most important provision why it has led to the scrapping of electoral bonds. So why they were introduced, I told you, to bring in, the government stated clearly when it was introduced in 2017 that previously the government, in case if there any political party, if they're receiving about 20,000, the donations, okay, political donations, only these have to be disclosed with the election commission. Any amount less than 20,000 need not be disclosed with the election commission. Then what happened? So as this, and that is only in the form of cash. So to increase the transparency in political funding, Government of India brought this electoral bond scheme, and they said any amount below 2,000 need not be disclosed, but above 2,000, okay. So if you get any money, that has to be through electoral bonds only. That means this bond buying and all this with SBI, in this way it enters through banking route. So you're ensuring that the money is coming transparently. So it will reduce the denomination from 20,000 to 2,000, as I told you, and it is making the funding more transparent because it is coming through banks. So this was introduced in 2018 by Finance Act, and the Supreme Court also has criticized introducing this electoral bonds through Finance Act or Money Bill. Okay, so that is another aspect. But what are the acts that were amended through electoral bonds is Income Tax Act, because income tax exemptions were given. Companies Act, as I told you, because previously only loss making companies and not allowed, and only profit making companies are allowed, and even they also can contribute only 7.5% of their profits to electoral bonds or political funding. Now FCR is also amended because foreign funding is also allowed. So Supreme Court also said in its recent judgment, when it scrapped electoral bonds, foreign funding will rule, or foreign companies, there may be a chance that foreign companies can rule the political mandate in India. And Representation of People's Act, why this was amended? Because not all political parties are eligible under electoral bond scheme, but under section 29A of Representation of People's Act 1951, whichever the parties are registered, okay, under this particular provisions, only those political parties can get the electoral bonds. In this way, these four acts got amended subsequently. Why they attracted criticism? Contradicting the idea of basic transparency. You said, the government said they're ensuring transparency, but if you're not revealing the donor's name, that is clearly violating Article 19. So this is what Supreme Court has understood. Compromising the right to know, and possibility of extortion. So money can be changed into hands, and it can be diverted in different ways, and it can enter into this electoral bond scheme only. Then against free and fair elections. So here, if you're not disclosing the information, then how you can say it is fair? So that is why it is against the free and fair elections. It is nothing but a blow to democracy, because the persons who are electing, they need to know to which political party they're voting. They need to know how much funding they're getting, who are contributing to the political party, and all these things. So it is a blow to democracy, and it may lead to crony capitalism. Crony capitalism means here the industrialists, okay, or the capitalists you have on one side. So they will be funding to the political parties. Later on, political parties, after coming to power again, they will do some benefits to the industrialists or this capitalists. This will lead to crony capitalism, mutual nexus, you can say. So electoral bonds, if they're not revealing their identity, then this may lead to crony capitalism. On these grounds, Supreme Court already has scrapped electoral bond scheme. Now, as we have discussed, let's see the practice question given in the previous video with respect to Sela Tunnel. What is the primary purpose of Sela Tunnel in Arunachal Pradesh? A, to provide all-year access, all-weather connectivity to Tawang and enhance the strategic and operational capabilities. This is the answer A. Then time for practice question. With reference to electoral bonds, which of the following statements is correct? A, beneficiary political party is required to reveal the identity of the entity that has given in the bonds. It can only be purchased by companies. Only political parties registered under Representation of People's Act 1951 are eligible to receive electoral bonds. D, all the above. So among the given options, choose which is correct with respect to electoral bonds and answer in the comment section. Then mains question for practice. Critically examine the effectiveness of electoral bonds to make Indian elections more transparent. Okay, so this is the mains question given for practice. As we have come to end of the video, today we have seen what did Supreme Court say with respect to disclosure of information related to electoral bonds by SBI. So what did it direct the SBI, and what is the stand of SBI? Why did SBI ask for extending the deadline till June 30th? We have seen after this judgment, interestingly, SBI share value has decreased by 2%. Okay, so decrease in share value also has been observed. Then we also have seen what is the contempt of court proceedings that Supreme Court has warned that in case of failure of information, disclosure of information, Supreme Court said even SBI will be initiated against SBI, this contempt of court proceedings will be initiated. So we also have seen what are the features of electoral bonds, who can buy, which are the parties eligible to encash this electoral bonds, and why Supreme Court has scrapped this electoral bonds. This is all that we have discussed as part of this video. Thanks for watching. Have a good day.